Hello students, I hope you all are staying safe. Please stay home, and at the same time it is very important for us to continue with our classes. As such, it has been decided by the college to continue with all the classes online. So this is the first video which I am uploading, and that is on what basically Moot Court is and how to prepare for Moot Court. Now, as we have already discussed earlier, Moot court is an artificial court. This is basically for the law students, and it is a kind of a debate on the specific cases. We are given a specific case, and we argue on those cases, right? The issues generally it is very imaginary. It's not a real life issue. It is the imaginary. In fact, the court is also imaginary. So it's Moot could basically during the law college days it gives us a practical experience of what we will be doing after we pass out from the law college and get into the real life court. So basically during the college days it's extracurricular activities. It is organized by many colleges, law universities. In fact, our university have also participated in few of them. Now, Moot court is a great method. It's a wonderful method of learning the law, learning the skills that require a student to analyze and argue both sides of a hypothetical legal issues using procedures. So mooting is considered a specific form of stimulation in which students are asked to argue points of law before a stimulated court. Now, moot court, however, does not involve actual testimony by witness or the presentation of evidence, but is based solely on the application of law to a fabricated legal issue. So, as in the real life cases, we have real life problems, we have witnesses, we have evidences. So, as moot court is a very not a real life case, it's an imaginary case. So we generally don't have witnesses, we generally don't have evidences. So everything in moot court is based on law. Okay, the moot court problem is designed to argue before the appellate form, because most of the college they are conducting national level or international level moot courts where judges are pretend to belong to the Supreme Court or International Court of Justice. But we have also seen that many events, many moot court events are organized at high court level or even at district levels. Okay, so where to get started in a moot problem? So before the moot court starts, we generally get a problem. Okay, so how to start? So the first thing we need to give is we need to read the problem as many number of times as we can. The more we read, the more uh, the basics of the problem, the basics regarding the topic involving the proposition clear up. Okay, so we need to understand what the problem is, how we need to research, what we need to research, where we need to go. Okay, a problem can relate to any part of the law. It can be criminal law, it can be constitutional law, it can be any other law. Okay, so the more we read, we will be able to understand, yes, this problem is related to criminal law, or this problem is related to constitutional law, or this problem is related to which law. Okay, so as give a reading as many number of time possible for you until you don't understand which way to go on with. So firstly, issues should be decided and divided among the team members. Okay, so you know the problem is there, the issue is there. So as you are well aware that there are three members in the moot court team, two speakers and one researcher. So you divide it among your team members, so it becomes, the research work becomes a little easier. Okay, so it is very important to maintain a constant coordination regarding the research involved and keep on discussing various lines of argument. It will make the work easier for all the team members, and then all the members can carry out their work accordingly. Okay, so For every moot court, like every court proceedings, we have two sides. Okay, the appellant and the respondent. So usually you have to prepare for both the sides. In the moot court, we generally prepare for both the sides. We prepare memorial for the appellant and as well as we prepare memorial for the respondent as well. So a moot court comprises of generally two speakers as one researcher, as I have already discussed with you. So they are written submissions, which is called the memorial, and we have a oral submissions. So the written submission of a memorial must contain the following things. Now, what are these things? And this should come up as explained in this video. So the first thing is the cover page. Okay. Now the cover page of each submission of memorial must have the following information. The cover page only we will have this information. The first thing is the name of the forum before which the proceedings are being conducted. Now say suppose we have imaginary names of the courts as well. So sometimes we have Supreme Court of Indiana, sometimes we have Supreme Court of Indica. So we have this imaginary names. So that name should come up before the which forum the matter is coming before. Then comes the title of the competition. So you need to write the name of the competition also. Say suppose the name of the competition is Sundranath Law College Sundranath Law College Moot Court competition. So that thing will also come up. The title of the competition will also come up. The next thing is the title of the memorial. Okay. So on whose behalf you are filing this memorial? Are you filing this memorial on the behalf of the plaintiff, or are you filing this memorial on behalf of the defendant? So those things will also be there on the cover page itself. Now this is very important. It becomes easier for the judges as well as the organizers to understand easily by the color, like whether it is for the defendant or whether the memorial is for the petitioner. So we give a color. Now this is a standard color in every moot court competition. This color is only maintained. So if it is for the plaintiff, petitioner or appellant, the color of the cover page will be blue, and if it is for the defendant, respondent or defendant or respondent, it will be red in color. On the upper right side of the cover page, uh, the team code. Remember the team code. Every team is assigned with a team code, and that team code should come. You cannot write your name, you cannot write the name of the college you are representing, you cannot write the name of the class which you are representing, you cannot write anything. No identification that from which college you belong or where do you belong. No identity can be revealed. So every team is given a team code by the organizers. That team code should come on the upper right hand side of the cover page. The next page is the table of contents. So we are well aware, we have seen in the books since our childhood that what the contents is. The table of content, it contains of the list of the chapters and paragraphs that are included in the memorial. You can also mention the page numbers of the chapters. If you do it, that is more better. In fact, you should do it. You should write the page numbers and of the chapter and the paragraphs. By mentioning the page number, it will be easy for the judges and the speakers to find out the mentioned argument. The argument is the most complex part of the brief, therefore the headings and the subheadings used within the argument should also be listed in the table of contents with the corresponding page numbers. Now next is the index of authority. The next page is the index of authorities. In this, all the materials which support your argument have to be added. Okay, whatever material you have used, whatever journals you have used, whatever statutes you have used, whatever parliamentary debates you have used, everything should come under the index of authorities. So in this, the authorities of Supreme Court and High Court, foreign judgments, statutes and parliamentary debates are mentioned under the index of authorities. The sources refer through articles, textbook, journals and website are also mentioned over here. This is not only harmful for the speakers but also useful for the judges and other side speakers to easily determine which case law or constitutional provision or statutes or other materials are being cited. Uniform citation method has to be followed. Citation is crucial part of memorial. It should be in a correct format. Citation helps to determine from where the certain cases, statutes or other materials have been taken. It gives easily reference to the judges from where certain part has been taken. Now we come to list of abbreviation. So in the next page we write the abbreviations which we have used. Suppose many where we write SCC, so we have to write the full form of the same abbreviations. That's Supreme Court cases. Suppose we have written AIR somewhere, so we write All India Reporter. So like this, in the next page the list of the abbreviation and the full forms should also be mentioned. Then comes the statement of jurisdiction. This is very important, very important. You need to mention the that whether how come this matter, the problem which has been given to you, whether it is coming within the specific jurisdiction or it is not coming within the specific jurisdiction of the court. So jurisdiction is the most important part of the memorial. The jurisdiction of the court should be clearly mentioned with reason. Finding the proper jurisdiction is very important. Judges surely ask questions, and thereby it is important to know the jurisdiction of the court. Now comes to the statement of facts or the synopsis of the fact. Now, the statement of fact or the synopsis of the fact are an important part in memorial presentation. It generally convinces the court about your client's position and its point of view. A judge may be well versed in law, but he does not know about the facts of your particular case. Okay, so a brief summary of the facts have to be written clearly in the beginning of the memorial, but generally it should not be more than 2 pages. Okay, so we are well aware that the judges, they are well aware of the law. Okay, now every case is a unique case. We go to the judge. Say suppose if we are going with a bail application, there are hundred of bail application file. If you see, there can be 10, say suppose if 100 matters is filed before a court and we find that 10 matters are 10 FIRs has been lodged under section 302, but the facts of each and every case will be different, so the judges doesn't know what is the fact of the case, right? So it is very important for us to briefly mention that what are the facts of the case, and we should keep this thing in mind that it should be in a summary way, it should be in a small way, so that it does not exceed more than 2 pages. Okay, we can make it shorter if it is 1 page, 1.5 page, more better, but in any circumstances we should not go beyond 2 pages. So a brief summary of fact have to be written clearly in the beginning of the memorial, but generally it should not be more than 2 pages. I repeat once again, it should not be more than 2 pages. Knowing of fact in a brief is very necessary, so it is important for a speaker to go through the facts carefully, and only relevant facts should be mentioned in your memorial. Fact should not be uninteresting. It should be in a manner that a person enjoys reading and it proves on your side. The fact should not be assumed one. It should be real as given in the proposition. Okay. So whatever proposition you get, whatever the problem which you are getting, so the fact should be based on that only. You cannot create something new out of your own. Okay. So remember this thing. I've seen people doing this. Please don't do this. This is a very bad practice and it totally spoils the memorial. Now we come to the statement of issues. This is a short introductory statement of the legal issues or point of law involved in the case. It tells the judges precisely what legal issues the speaker wants the court to decide. The statements This statement should be phrased to help one to argue for a particular conclusion rather than simply against the other side. These issues are stated in the question form and should be phrased in such a way that it showed on its favor side. These issues are very short and not lengthy, so as to make an individual understand the very essence of it. They are not more than one sentence. The sentence should start with whether and end up with a question mark. Okay. Next, coming to the summary of argument. So, what is a summary of argument? Summary of argument is basically a brief summary of the issues raised, the brief summary of arguments based on the issue raised. It is a short introductory of issues mentioned in the memorial, and each argument should not be more than one paragraph. It only shows what you are arguing in a brief manner. Now, this is a very major portion of the entire memorial, argument advance. So, you can also say that this is the heart and soul of the entire memorial. Okay, this is very important because on the basis of this only you will be making your oral submissions as well, and on the basis of this the memorial marks which are contained you will be getting over this is a major part which contains the memorial marks as well. So every part of the argument must be supported by a legal authority. Arguments should be well organized and convincing. Each point the team wants the court to consider in deciding the case must be described, the reasons explained with appropriate reference to research material used, and text citations should be inserted as frequently as needed. Arguments should be addressed legal precedents and policy issues. Each part of the argument first addresses the issue supporting one's own case. Then the address contention anticipated to be brought up by the opposing party. The argument should be written in forceful, active, positive language. It is best to avoid the passive tense, so we should try to keep it in the active tense. Headings and subheadings are used to help in clearly organizing the arguments. The same structure of headings and subheadings should be summarized should be uh, should be summarized in the table of contents. The idea is to do everything in terms of both forms and substances to help the court understand the reasonableness and logic of the argument and decide in one's favor. Now this is the last portion. This is the prayer portion. Okay, okay, what relief we are seeking from the court. Okay, so it is a relief claimed by the parties which should be clearly mentioned. More than one relief can be claimed in one clause of action. Following the prayer signature of the council must be stated. This act of the ending of the memorial. This clearly declares what an individual, be it a petitioner or the defendant, actually wants from the court in his favor. This is the relief mentioning sentence, and in it basic motive of filing the suit is mentioned through relief claim. Obviously, when we are filing a suit, we are filing a petition before the court, we are filing it to get some relief from the court. Say suppose if you are filing a bail application, so we are filing to get bail on behalf of the client. Now this prayer portion contains that portion, that what relief we are seeking from the court. So we need to mention over there that we are seeking for the bill or whatever the matter is similar as per the matter what relief and whatever relief we are seeking we need to mention in the prayer portion. The above written memorial must be uh, must be well versed English. It does not mean a typical type of English. By reading, one should understand. Writing should contain legal quality. After preparing memorial, it is very necessary to go through the memorial at least 3 to 4 times, and it is necessary to write in a correct format, no grammatical mistakes. Otherwise, it will not bring out the true essence of